guys, the court in the federal case Bianco versus Marilyn Manson has issued an order which provides the depositions are going to start moving forward. Rules on the motions related to Ashley Walters, also gives an update on the sanctions situation, so we'll go over all of that. If you remember, Ashley Walters, who had filed her own lawsuit against Marilyn Manson in state court, but that was tossed out, was subpoenaed as a third-party witness in the Bianco versus Manson case. Her attorneys eventually objected to that, and the negotiations broke down, and it came on before the court for a motion to compel by Manson to force her to come to a deposition and also to provide documents. So there were three things in contention in that motion. First, what documents did she need to provide, if any? Secondly, what would be the scope of her deposition? And third, who was going to pay the cost for this fight? So we'll pick through those and we'll see what the court said about those three issues, and then we'll move on to what the court said about the sanction stuff. So the first one is the documents that have to be provided before the deposition. Manson had asked for documents between Walters and Bianco and Evan Rachel Wood and Ilma Gore. Anything that related to him is what he asked for. What she counteroffered, I think, was 5 years of documents between her and Bianco that related to Manson. So that they didn't reach any agreement on that, and that went before the court to decide what's the right answer for that. So I had done a previous video on this and gave some predictions. I'm gonna show those predictions as we move through this to see how embarrassed I should be for trying to anticipate what the court might do. Give me a little break here. I don't know the judge. I've certainly never practiced in front of that court, just going off of my own reading of the briefs and what I think would be quote unquote fair. So let's move on with it. Walter's attorneys had made the arguments that the items being sought would invoke confidentiality, that it was all overly burdensome, and that it would be beyond the scope of things that would be necessarily relevant for Manson to have in his deposition. The confidentiality argument to me didn't seem like it would be persuasive because there is a confidentiality order and she can come under it and she can designate things as confidential. And just the mere fact that she feels like something is confidential is not by itself a reason to withhold evidence in a case, especially when there's a protective order issued as there is in this case. And the court didn't find that persuasive either. The other aspect was the burdensome aspect, and the court noted obviously that she had been her own plaintiff in a case against Manson. So really, how burdensome could this be? And the 5-year time frame wouldn't work because some of the allegations were over 10 years old anyway. And then finally on scope, the court did find there that the court would limit the matters to those things that are responsive to allegations that Bianco made or the defenses that Manson raised. So let's see what I said I thought would happen.
And you're in discovery and you have information that supports either side's ability to make their case or defend themselves, you're supposed to turn over that information. This doesn't ask for her personal history. This doesn't ask for her communications, all her friends and families. It doesn't even ask for any communication she had with anybody about Manson, only about these three people. So in my opinion, Manson should win this side of the document fight and get these documents. That's my opinion. You can have a different one if you want to. One thing we can agree on, it doesn't matter whose opinion is what, because the court will end up deciding it later in October.
So I thought that because they were only asking for 3 people's worth of communication, they would just get it. They certainly couldn't limit that and say that she only has to talk about what Bianco said. That to me is crazy restrained. So I wasn't exactly accurate there because the court there did limit this to some degree by saying she does have to provide the documents related to these 3 people, but only if they relate to things that are in the lawsuit Bianco raised or defenses that Manson raised. So there is some limit there. So there could be some documents that don't involve those things. She wouldn't have to turn those over. So not too far off the beam there, not exactly accurate, but not too far off either. Let's move into the second issue, which is the deposition scope. So Walter's attorneys had raised some similar concerns. You know, this is confidential, it's too wide-ranging, it's a fishing expedition, and things like that. And Manson's attorney said, hey, look, we're entitled to take her deposition. These aren't appropriate arguments at this stage, right? And she's not entitled to tell us what we can ask, basically was the response there. So let's see what I said about that.
And then if we knew the general topics, then we could say we object to this topic or we don't object to any topic. And I am sympathetic to that aspect of what they're saying. I could see the court saying we're going to order you to come to the deposition, but we're also going to order the subpoena to be modified to lay out the topics that will be covered.
So my idea was that because she's a third party, she's not a party to this lawsuit, and so she's entitled to a little more protection than the parties would be, that the court could reasonably find that, hey, look, at least tell her what the topics of the deposition will be so she doesn't have to prepare for all this wide-ranging things. And also that way, if you know ahead of time what the topics are, you can have any fight before she shows up for a deposition. This thing will go more smoothly. So what happened apparently in the court argument is that idea came to fruition. I'm not taking credit for it. It's not like it's the first time it's ever happened. And there was a list of topics going to be proposed by Manson's team to Walter's attorneys before the deposition. So the court adopted this idea and said, hey, at least X days before the deposition, this list has to be turned over. The court did seem skeptical that this would have the laudatory effect of having no more disputes about the scope of the deposition, because the parties could look at the list. If Walters thinks this topic should be off limits, she can say so, they can agree or whatever. And the court said, if either one of you come back here arguing over this list, the court's probably going to award expenses against the losing side. So in other words, if you don't like the topic, you should be really sure that the court's going to agree with you before you make that a subject of dispute. And likewise on Manson's side, if you propose a topic, you should be pretty confident the court's going to think it's relevant to what you're entitled to ask about if you're going to insist on it. Otherwise, you're going to end up paying the cost if this is another fight. This was kind of a theme through the court's order, which is nobody's getting hammered right now, but if you come back on this stuff again, you're going to see a little different tone coming from the court's order, and probably an invoice associated with it. So the third thing is expenses on this motion. Manson's team had wanted expenses awarded, and the court addressed that. Let's see what I said about it.
Non-party, and you're kind of making a good faith argument to the other side about what's going on with discovery. It's often the case that the first one is free, that the court's going to say, okay, we're going to order this. Okay, you're going to have to comply with the subpoena as it's drafted, or you'll have to comply with the subpoena, but it has some limits on it, and we're not awarding anybody's costs at this point. And I think that's most likely the outcome.
So I thought the court in this case wouldn't and shouldn't order expenses at this stage, and that's what happened. The court said, we're not even really sure what the court's authority is on third parties at this early stage of a dispute, but in any event, we're not going to award expenses right now. They did mention, as I say throughout the order, if you guys keep coming back on this stuff, though, somebody's going to get the hammer at some point, is basically the thrust of the court's communication, in my opinion. So the court orders as follows. The defendants, that's Manson, motion to compel documents pertaining to all written communications with Esme Bianco regarding Brian Warner is granted. Those documents will be provided at least 48 hours before the date of the deposition. Defendants, Manson's motion to compel documents pertaining to all written communications with Evan Rachel Wood and Ashley Gore without limitation is denied. The court imposes a protective order and limits the scope of this production to all written communications with Wood, Gore regarding Warner that pertain to Esme Bianco's allegations in the complaint or that implicate defendant's potential defenses. So he doesn't get it all without limitation. He gets it with a limitation that has to have something to do with the lawsuit or defenses in it. It seems fair. Defendant's motion to compel Ashley Walters' deposition is granted in part. Counsel will find a mutually agreeable date within 21 days from the date of the grant of this motion to take that deposition. The motion to compel the deposition without limitation is denied. The court imposes a protective order limiting the scope to include only topics provided by defendants at least 7 days before the deposition, and those can't have anything to do with their personal sexual history. Both parties' requests for expenses are denied. So let's look at a few things that the court said in here that are maybe just worth pulling out and quoting for a court order, I think. The court gives this admonishment really to both sides, not surprised to see this, saying that as it reviewed the emails, the court notes both parties appear to have contributed to an eventual breakdown in fruitful communication. Because this case deals with sensitive subject matter, the case has already produced and will probably continue to produce discovery disputes. With that in mind, both parties are cautioned to remember that while no one expects the deposition of a key witness in a hotly contested case to be a nonstop exchange of pleasantries, both parties have a general responsibility to approach the deposition in good faith and avoid unnecessary court intervention. And the court says this: the court will not treat either party as graciously should these matters come before it a second time. Accordingly, both parties are admonished to work together in good faith to complete the deposition and reach agreements on future discovery disputes. And they also did say if somebody shows up for this list, arguing over this list of topics. Whoever loses is probably going to be paying. So the deposition of Walters will move forward within 21 days. It should be the case that the deposition of Gore in the Wood-Gore case has already occurred, so depositions are starting to move forward. Also filed a similar time frame to this order from the court was a motion again by defendant Manson to move to compel another third party, a social worker. So I'm not sure why that needed to be a motion to compel. There could be legitimate reasons for that beyond just people wanting to argue because of the nature of that position. And it caught my eye that she was a licensed clinical social worker, I think. But more depositions on tap and coming. So let's look at Bianco's argument about sanctions and about staying the case. So remember that Bianco had asked for sanctions against Manson's attorneys, and this order reveals that it was over some kind of discovery breach of confidential material, apparently. But the magistrate judge denied the request for sanctions. So, of course, we went over a little bit in the previous video about the lengthy names of filings where Bianco's attorney has asked the court to reconsider that order and overturn it. And also, I didn't realize this, asked for the case to be stayed while that was pending. In fact, it says, plaintiff asked this court to stay its judgment on the motion to compel until the district court had ruled on the plaintiff's motion for review and reconsideration of this court's September 30th order, which declined to impose sanctions on defendants for the alleged discovery breach. So the court notes what it would have to do if it wants to potentially overturn the magistrate judge decision, which is, it has to be clearly erroneous or contrary to law. But it also says previous orders remain in effect while your motion for reconsideration is pending. Then it lays down the law on if you want us to stay any of these proceedings, here's what you have to show: a 4-factor test. You have to show a likelihood of success on the merits. You have to show irreparable injury if the stay is not granted, whether the stay would substantially harm the other parties, and whether the granting of the stay would serve the public interest. Note what the court says here. Plaintiff has presented no new evidence that would show the motion for review is likely to succeed on its merits. Under the same facts and evidence presented in the parties' briefing on the motion for sanctions, the court cannot find its previous ruling was clearly erroneous or contrary to law. Also, Bianco has not shown how she would be irreparably harmed or other parties would be substantially harmed if the stay isn't granted. In fact, it's unclear what, if any, effect the dispute over sanctions between the plaintiff and the defendant has on the dispute between the defendant and Walters. To the extent Walters is concerned with the security of her discovery, in light of the alleged breach, the court is sensitive to that. But as noted several times throughout this order, the protective order greatly mitigates security concerns. So the court's kind of tipping a hand there that we've read this stuff and we don't think that the order was wrong in the first place, or certainly not to the degree that we're going to be overturning it. So that makes it sound like the denial of sanctions is going to stand, and the effort by Bianco's attorney to stop the case, the motion to compel until this reconsideration was heard, that was unsuccessful in this order as well. So that makes its way into the order at the final part where it says plaintiff's request for a stay pending their motion for reconsideration before the district court is denied. So that's what's going on in the Manson cases. We finally got a lot of clarity from the court on where these things stand, and talk to you later. Thanks.